G'day everyone, my name's Nigel. I'm a lawyer here at Aussie Injury Lawyers. Today I wanted to speak to you a little bit about TPD claims. A TPD claim stands for Total Permanent Disability or Total Permanent Disablement. It's the insurance that you have in your super, so when you see your member statement come back from your superannuation fund, you'll see a number of different figures. The first figure will relate to what's called your member balance. That's the amount of money that's been invested on your behalf through the payments made by your employer, and that's your long-term savings for your retirement. You'll also notice on your member statement a number of other figures that relate to insurance. Typically, you'll have death cover, and that'll be for a certain amount. You also have one called TPD, which is the Total Permanent Disability cover. That'll be for a separate amount, and sometimes you'll also have income protection. Now, the one that I wanted to speak to you about today is the Total Permanent Disability. Total Permanent Disability is a little misleading in its name because by a logical explanation of it, you would assume to qualify for Total Permanent Disability, you would need to be basically almost in a vegetative state or unable to work whatsoever because of a catastrophic injury. People tend to always think that they wouldn't have an injury significant enough or an illness that was serious enough to make them TPD. The test for TPD, there are basically two very simple ways on which the assessment is made. The first is what we call the standard test, and that's the most common. If you're employed leading up to becoming TPD, then your assessment for TPD would be under what we call the standard test. And that is that you're unable to return to the work that you're previously trained or experienced in. The other type of test, which is much harder to satisfy, is what's called ADLs, Activities of Daily Living. To qualify for TPD on that test, it's usually the case that you've either taken out a retail fund, in other words, you've gone to a financial planner or an insurance broker and taken out your own policy. Unfortunately, very often those policies are done with a definition which is ADL, and it's something that we see quite often. What happens there is that to qualify, you need to be unable to do 3 of usually 5 tests, which relate to things, basic activities such as feeding yourself, clothing yourself, bathing yourself, etc. The standard test, though, is the one that I spoke about, which is not being able to return to employment that you're trained or experienced in. So if you are eligible for a TPD claim, how does it all work? For example, if you had a member balance of $100,000 and you had a TPD claim of TPD amount of $300,000, if you are approved for your TPD payout, the day they approve it and make the payment, what would happen is your $100,000 member balance would go to $400,000. You are then eligible to withdraw, irrespective of your age, because you've been determined to be TPD, you're eligible to withdraw none or all or some part of that amount of money, notwithstanding your age. The process that we follow is that we would typically speak to somebody by way of an initial inquiry. We'd receive a response to one of our quizzes that we have on Facebook or on the internet, and we'll make contact with people. We would then run through a process just to pre-qualify you as to whether you're likely to be eligible to make a claim, okay? The next step, once we get past that initial screening process to make sure that we're not wasting your time or our time, the first thing we would do is go ahead and confirm cover. That is, we'd contact your superannuation fund, and if you don't know who your fund is, we would make inquiries with the ATO to do a lost super search on your behalf. Once we identify that you have got cover, and the other thing that we need to determine in that early stage is what is your D-law. When we say D-Law, we're talking about the date last at work. That's typically the date that you will be using to determine what is your date of TPD. So for instance, if somebody stopped working in January 2018 because of a heart attack, we'd go back. If you contacted your super fund today and said, how much TPD cover do I have? That's not really relevant because the time that we need to look at is when you stop working, typically. So we'd go back to the fund and we'd say, we act for your member. We'd like to know how much cover they had as at January 2019 or 2018, I think was the example. Once we know that figure, then we're able to confirm your level of cover. We would then knowing that there is a pot of gold at the end of your particular rainbow, we would then make further inquiries with you and gather a lot more information to really shore up the claim and make sure that it's likely to be successful. We would then go ahead and lodge a claim form on your behalf. Now, if you have multiple funds, some people have many superannuation funds, we would go through each of those funds to ascertain whether you have cover. And some people are eligible to make multiple claims, which is obviously good for them. And one reason why people almost apologetically say to me, oh, I meant to consolidate all my funds, I know I should have. Well, the good news for people who haven't is that quite often they will get multiple claims. We then go about gathering the evidence that we need to establish your claim. And there's basically two types of that evidence. One is financial, your tax records, your Centrelink records, things of that nature. And then, of course, the medical evidence needed to support your claim. What we will do is contact your treating practitioners and have them complete what we call a MAS, a medical attendance statement. Those documents, together with the claim form and the financial information, are submitted to the relevant funds for their approval. What they will do typically is have an insurer involved or a claim assessor team involved. That will get passed on to them, and then the process begins with a bit of back and forth. What we would endeavour to do is to make sure that the information that we give them is absolutely comprehensive. So we put them in a position to make a fast determination on your behalf. What they'll do is pass it over to the insurer. The insurer will go through, look at it all. They'll seek further information. And one tip that I suppose you can have is the more that we give them, the less they have to go get. We're a lot keener for you to get it than they are to give it. So we would try and, I suppose what we would do is try and ascertain what we think they're likely to want, and as much as we can, put them in a position to get that. Once your approval has been made by the insurer, they'll send it to the trustee of the fund for formal final approval. And then once approved, they'll send out withdrawal forms for you to withdraw some or all of your funds. At that stage, it's imperative, before you action it, to think about whether you require financial or accounting advice, because the payment of a TPD claim into your super fund has very little effect on tax or Centrelink or things of that nature. But once you start withdrawing the money, you need to make sure that it's done in the most tax and Centrelink effective manner. And what we would do typically is offer you the opportunity to speak with a firm of accountants with whom we're associated, and they will give you the advice about what you should do. What we would do is speak to you about payment of our legal fee, and that money is only paid to us from the payment made into your super fund with your approval. There are a number of misconceptions that are common when you're talking about TPD claims, and we seem to get asked the same questions quite often, which is totally understandable. The first thing is that people will say, but my accident didn't happen at work. The answer to that question is that it really doesn't matter how you come to be unable to work. It's just that you cannot work. It doesn't matter whether it's an illness or an injury. So whether it's an accident at work or an accident at home, sickness, illness, none of those things matter. The cause of you being unable to work is not really the issue, or how you came to be injured or unwell. The question is, can you not go back to the work that you previously did? Another question that we're very commonly asked is, my accident or my illness that kept me from working happened 15 years ago. Isn't there a 3-year limitation period? Typically, there's a 3-year limit when you're doing a common law claim for a work accident or a motor vehicle accident or a slip and fall. In TPD, that doesn't apply. So we can, as long as you've got cover and we can go back, we're doing claims for people back to as far back as the year 2000, going back, identifying their cover, and then putting in a claim for them. The next question is that people will often ask us, what happens if I don't have any money now in my fund? My fund's been closed. The answer to that is, it doesn't matter what the current state of your superannuation fund is today. The relevant time is, what was it 10 years ago, 3 years ago, 1 year ago? That's the question. So if you've taken all the money out because of hardship, which is so common for people in your situation, in that situation, what will happen is that we will go back to your details as at the D-Law, the date that you last worked, and it's the insurance that you have then that is relevant. The next question that people have is, oh, but I can do some work, so I wouldn't be eligible. The answer is, can they go back to the work that they are trained or experienced in? If you're a truck driver and you can't drive a truck, you might be able to physically sit behind a desk and do administrative work. But if you're a 55-year-old truck driver who's done nothing but drive trucks, then you're hardly going to be trained or experienced or have any real chance of retraining into that role. The other question is whether it's worth doing a claim after legal fees and things like that. The way that our legal fees work is that under the Law Society guidelines, we're obliged to enter into a client agreement with somebody if we're doing a claim of this nature. Now, what we would do is, because we know what the target we're shooting for is, what we would do typically is enter into a client agreement with a client, but so that you have certainty that it's not all going to get eaten up in fees, we would agree to charge according to our standard client agreement, but cap our fee at a certain figure. So, just to give you that surety of that it's worth doing financially for you. The next question is, what happens down the track if I can go back and do some sort of a job? The answer to that question really is that the test for your TPD claim is the test of your inability to work at your D-Law. And there are plenty of people out in the workforce now who did a successful TPD claim and then found some other job down the track that was suitable, notwithstanding their particular problem. No one is preventing you from doing that, and you're certainly allowed to do that. The next issue is, and it's a very common question, my injuries are only psychological. I don't actually have any physical injury as such, and my problem is purely psychological. To be honest, that's probably the most common claim that we do. People are unable to work because they've suffered workplace bullying, had a mental health problem, developed depression, developed severe anxiety, and those claims are very viable and absolutely very common. We successfully conclude claims like that all the time. There's another question again, and I touched on this a little earlier, and that is, what happens if I didn't have an injury, I just got sick? Again, there are plenty of claims that we've successfully concluded for people where they became unwell, they had a heart condition, they developed cancer, they had motor neurone disease, they had any number of things. The list is as long as your arm as to the different causes as to why people are in that situation. One very hot topical question that we get asked regularly every day, what if I get an injury from the COVID-19 vaccination? Can I make a claim? if you go back to first principles, these claims do not succeed or fail based on the cause. How you came to be unwell is irrelevant. So if you have an adverse reaction to the COVID-19 vaccination and you can't work, that is completely a separate issue. So that's fine. If that's the cause of your injury and it's a permanent condition and it's going to preclude you from being able to return to the work you're trained or experienced in, we can certainly do a claim. And we are doing quite a few of those claims as they're starting to happen. One question, the other question that we get asked, again, basically daily, is what if I'm forced out of work because I don't want to have the jab and my work are mandating it? Unfortunately, that isn't a situation that we can do a claim for because it falls outside the scope of a TPD claim. It's not a total permanent disability. It's an understandable, I suppose, choice that somebody's making. So unfortunately, we can help you if you have the vaccine and get unwell because you perhaps qualify for TPD. If you choose not to have the vaccine and lose your job, completely understandable. And I definitely feel for the many thousands of people across the country who've had that situation, but it falls outside the scope. So if you feel that this is something that would be of interest for us to assist, please do get in touch. Contact me on